Okay, good morning, council. Let's see, we have set this case this morning for 15 minutes of argument per side, and you'll just announce your appearance for the record and let us know how much time you want to reserve for rebuttal.
Good morning. May it please this honorable court, my name is William Cornwell, along with my colleague and co-counsel Cynthia Angelos.
Good morning.
And my partner Howard Weiss. We're here on behalf of FVP Miami Lakes, LLC. I'd like to reserve 2 minutes for rebuttal. This appeal arises from a declaratory judgment action to recover a portion of over $4 million in traffic, water, and sewer impact fees paid in 2005 for a proposed development of 207 acres in unincorporated Indian River County. The action also seeks a declaration that the Indian River County Code Section 201.08 is invalid to the extent that it permits and authorizes monthly water and sewer service charges against properties such as the properties we're here about, which are not connected to Indian River County's water or sewer systems.
Your client, if I have my facts right, acquired the property from Lennar.
That is correct.
The company that initially made a financial decision to pay these fees up front, correct?
That is correct.
And you took ownership of the property knowing that had been done?
Yes, and we took an assignment of all rights to recover, if any, right to the impact fees. The impact fees at issue were paid by Lennar, and to obtain, though, required concurrency certificates to construct 462 single-family dwellings, the plans for which had already received preliminary approval from the county at the time the fees were paid. The plans did not receive final approval and have no legal possibility of ever being constructed. Significantly, in the 11 years since the impact fees were paid, the land at issue has imposed absolutely no impact on the county's water, traffic, or sewer services, and the county has conferred no tangible benefit in the form of water or sewer improvements to the property at issue. In addition, since March 19th of 2005, when the impact fees were paid, the county's water and sewer utility has levied service availability charges of over $10,000 a month on the properties, in spite of the undisputed facts that the properties are not connected to the county's water or sewer services. The properties do not now and never have had the capacity to connect to the county's water or sewer services, and no building permits have ever been issued for construction of any improvements on the properties.
Did the county undertake anything as a result of the payment of the fees? Did it do anything to expand in preparation for what they thought was going to be construction of a new development?
The county, and this is, we've not pursued recovery of the impact fees paid for traffic impact fees for the 315 units that were ultimately subsequently approved, and the county will tell you they encumbered those funds in 2006 for roadway improvements. We're not pursuing recovery of those
But that's
fees.
the only expenditure that the county made as a result of these fees being paid?
Yes. The monthly charges, back to the base facilities or service availability charges, which were paid through 2009 when my clients acquired the properties, have accumulated with interest and penalties assessed by the county to over $1.4 million, which under the county's code serve as a lien against the properties. The county's water and sewer utility continues to assess these monthly service charges as if the properties have 462 homes on them, despite the fact that the county only ultimately approved 315 homes for construction in November of 2006.
Doesn't the case law, though, indicate that the mere availability of use confers a benefit by itself?
No, it doesn't. In fact, and I'll get to those cases in a few moments, the cases, if you look carefully at each and every one of them, involve situations where someone is connected to the water, sewer, or has an improvement on the property and is obtaining garbage collection service, for example, and complains or chooses not to use the service. Those cases say it's the availability of the service that gives rise to the charge, because the county has to stand ready to deliver service at any moment. For example, the one that comes to mind is the town of Reddington Shores, and I think the I-4 case that's cited over and over by the county, where the complaint was either we're not making use of the service we have a 2-inch water line, for example, and an 8-inch line that we're being charged for because that 8-inch line is available in case there's fire protection needed, and we don't want to pay for the 8-inch line. Those cases all uniformly hold that whether you use that service or not, the county has to stand ready at any moment to deliver the service. Here, importantly, there's no service connection. There isn't even any possibility of being connected to the service.
So you were attempting to get back, if I understand correctly, not the traffic, but the water and sewer impact fees that were, number one, paid by Lennar in advance, and were you also paying the monthly assessments, or those did not go on?
They were paid through 2009. Since then, they've accumulated as a lien against the property.
Okay.
Go ahead, I'm
Okay.
sorry.
No, you're right. So if we looked at this and said, look, Lennar made a business decision back then before your client got involved and decided to pay the fees up front for whatever reason they decided, would you separate that amount from the subsequent assessments that were made against your client monthly, and now apparently some are unpaid and have a lien? I mean, can they be separated?
And I assume we're talking just about the service availability charges as distinct from the impact fees that were paid at the initial point in time.
I'm just trying to say, like, I can see in one respect that if Lennar made a business decision to pay them up front, that they may have waived the argument that they are able to be recouped because they didn't build, and there was no impact on the county. On the other hand, ongoing after that happened, the impact fees that are accruing each month, some of which were paid, some of which apparently now constitute a lien, could be a different type of damage, I see.
Clearly, a waiver requires knowing, voluntary, and being seized with all the facts. Here, both parties, that is the county and Lennar, had this factual belief that 462 homes, which had been preliminarily approved, would be constructed, and more importantly, would be fully and finally approved, which
Right.
wasn't the case. With respect to the service availability charges, it's a facial challenge to the ordinance itself, because those charges are being levied, and I'm going to get into this briefly in a minute, as user fees, and this court and the
There's no
Supreme
use.
Court of this state, yes, have very specific factors governing the charging, levying, and collection of user fees, first and foremost of which is that it's a service. Here, there's absolutely no service being provided. You're going to hear from the county, oh, yes, there is. We reserve capacity in our sewer and water plants. Well, that's what the impact fees were paid for. There's no service being paid. And so we've facially challenged that ordinance, which, by the way, only allows one to quit paying these fees if and when they permanently disconnect from the water and sewer service.
But you've
Eric
never been
Olson-
connected.
Correct. Eric Olson, the Director of Utilities, who I deposed in this case, very candidly admitted that one who never connects will be charged these fees in perpetuity.
Because you can't disconnect what's not connected.
Correct.
But you're not just seeking the refund of the service fees or to get those eliminated. You're also seeking the impact fees that were prepaid by Lennar.
That's correct.
Was there any provision in the Indian River Code for refunds of the impact fees for the water and sewer?
There is no provision one way or the other. The county argues that they don't allow for refunds. In fact, the record shows they do allow for a process by which the ERUs that are issued when those fees are paid may be sold or exchanged with those who come in the future. There's no prohibition against refund of the water and sewer impact fees. There was a no refund rule applicable to the traffic impact fees. Quite frankly, that rule runs counter to Cardillo versus Florida Keys Aqueduct Authority, which is a very important case. In fact, the only case in Florida that's addressed this issue, where in the underlying order from the administrative hearing officer, the court concluded the fees were voluntarily paid. The officer concluded that the fees were not refundable pursuant to both a Florida Administrative Code section and a specific water services agreement entered into between the developer and the authority. And notwithstanding that, the Third District Court of Appeals, when looking at the case and determining that the construction that had been undertaken and was stopped in midstream because an adjoining landowner successfully challenged the issuance of the building permit, concluded, notwithstanding those facts, that because there was no nexus between the service being provided and the fee that had been paid, the words they used was that it defied logic, and they reversed the administrative hearing officer's decision and ordered a refund of the fee. Here, there's absolutely no evidence that there was a business decision made to prepay these impact fees. The evidence, quite frankly, and it's the only evidence factual from John Lynch, the Lennar representative who was in charge of the project at the time, said that Lennar felt it had no choice in the decision because they could risk $10, $15 million developing these properties, and if they waited until building permit issuance, be told there was no capacity in the system. They were being told at the time they needed to prepay the impact fees. They didn't do so to save money, is the point, like they did in Cardillo.
Isn't Cardillo, though, distinguishable? Because in that case, the building permit was rescinded through no fault of the plaintiff in that case.
Well, in all candor, I hear your point, but
Project.
that's sort of a circular argument because they went and sought approval from the permitting authority representing that under the Land Development Code in Monroe County, the permit was issuable. The county issued the permit based on the plaintiff's representations, which later turned out to not be true. So to say that it was due to no fault of the plaintiff is not entirely correct. Here, the impact fees were paid based on both parties' agreement that the plan submitted and preliminarily approved would allow for the construction of 462 homes, which later turned out not to be true.
Well, was there any true legal impediment to actually building out 462 homes in these two projects?
Yes, there was. I mean, economic impediments.
Well, that's another business decision, though.
Well, but there's no requirement that the landowner, to justify the payment of impact fees, make an economic decision to take an enormous loss and build out the property in a manner that wasn't the basis for which they paid the fees. The fees were paid based on a specific set of plans that the parties agreed.
Wasn't that, the difference in the amount of homes that could be built due to Lennar's engineering error? Not the fault of the county.
Again, an engineering error that was missed both by the county and the engineers for Lennar. Yes, is the answer. But again, the payment of the fees in order to be considered voluntary under the case law cited by the county and its Supreme Court case law says very clearly that payment of fees based on mistake of fact are in fact involuntary and compulsory, and the fees may be recovered. That's the North Miami case that's been cited by this very court in its 1982 decision of S. Carpenter. Turning our attention to what the trial court did, frankly, the trial court granted summary judgment to the county on the basis of, erroneous basis of the statute of limitations. The county urged that the statute of limitations began to run in March 2005, and under Vess Carpenter, which this court issued in 1982, which was a facial challenge in an instance where the municipality had failed to enact a proper enabling ordinance. The fees were illegal on the date they were paid. Here, we don't challenge the impact fee ordinance. We don't say it was illegal on its face. We say it wasn't until 2007 when subsequent plans were approved, reducing the density from 462 to 315, that as applied when we were denied the incremental refund request in October of 2007, that because the county could no longer justify the fees based on the dual rational nexus requirement under Supreme Court, long established Supreme Court law, that's when our claim arose with respect to the impact fee refund. It was not until 2009 that Lennar notified the county within the 5-year period of the concurrency certificate that it no longer intended to go forward with the construction of anything on the property and asked for the entire water and sewer impact fee refund, which was not barred by the ordinances, that the county responded that it wouldn't refund those fees, and that broader impact fee refund claim came into existence. We filed this action in October 2010, well within 4 years of those two events. Both sides agree that the statute's 4 years. I'm sorry.
No, that's okay. I'm just, to get so you have the amount that Lennar initially paid, then you have these monthly assessments, and you have the monthly assessments can actually be divided by what they assessed you versus what they authorized to be built. There was a gap in there because they authorized less homes than the amount that you're and you're continuing to be assessed for the total amount and not the lesser amount that was approved, correct?
That's correct, Your
What
Honor.
are we talking about in terms of dollars in those three categories?
It's about $20 to $22 a unit, if I recall correctly from having looked recently at the bills. The problem with that charge, and I'm going to move right to that since Your Honor has questions about it, is that nowhere in the history of Florida jurisprudence has any court, any appellate court, ever approved service charges for unconnected property owners. I can't emphasize this enough. As I said previously, the only way to avoid these charges once impact fees are paid under the code section is to disconnect permanently. And if you never connect, as I said, the county admits you're going to be charged these fees in perpetuity. And they're not small charges. As I said, they amount to about $10,000 a month, which with interest and penalties accumulate right now to over $1.4 million.
On just the things that happened after the payment was made by Lennar?
Yes.
Okay.
Yes.
Would you
In
like
fact,
to,
after 2009, when the sale,
we're getting into your rebuttal time
Yes.
now. If you want to just kind of wrap this up and
Yeah,
continue.
in wrapping up, I would simply say that none of the cases cited by the county support this charge, and none of these charges qualify as a valid user fee under the state versus City of Port Orange, the seminal case from the Supreme Court. Thank you for your patience.
Thank you.
Good morning, may it please the court. My name is Casey Walker, and together with my law partner Will Murphy, we're here on behalf of the appellee, Indian River County. And I think it's important to start off, to back up and take a look in the big picture of factually how this came about. FVP's predecessor, Lennar Homes, proposed to build 2 projects in Indian River County. What happened in a nutshell is that when Lennar's own engineers designed their comprehensive plan, their proposed plan, site plan, they miscalculated on their drainage calculations. It's what the applicable land development rules are is that you can build a project and you can alter elevations, you can raise building pads, and you can construct roads, but at the end of the day, your project cannot shed any more stormwater off of it than it did in its natural state. So basically, if you build up a housing pad here and a road here, you've got to cut a lake over here so that you don't have stormwater running off and burdening an otherwise already burdened system. In a nutshell, an even smaller nutshell, what happened here is that the engineers designed the lakes, they were too small. So the lakes had to get bigger. In order for the lakes to get bigger and maintain the same 462 units, you had to do something with the units. You either had to go multifamily in portions, the way Lennar's portfolio manager testified in his deposition, or as the county's community development director said, you could reduce the footprint of the houses, reduce the driveways. Basically, you can take McMansions and make them into townhomes in spots. That was purely a decision that was within Lennar's purview.
I'm not as concerned about Lennar's initial payment because to me it seems like it was a decision Lennar made as a business decision, like Southwest bought all the gas before the gas prices went up. But I am concerned about the fact that the county continues to assess against the properties monies and fees for services they don't receive, and I don't see where the county's done anything to have incurred any cost to the county that these fees would help defray.
Well, as our Utilities Director, Eric Olson, testified, the county in fact did expand its wastewater and sewer systems in addition to the traffic systems. They built wastewater treatment system expansions, including the construction of an entirely new plant, the expansion of an existing plant, and a large force main allowing the county to move wastewater in the south end of the county where these projects were, up to the north end where the main treatment facility was.
Is that covered by the initial payment by Lennar?
Yes.
Okay, so I'm not worried about that. I'm worried about this continual assessment that will happen until it's disconnected and can't be disconnected if it's never connected. That
Yes,
doesn't-
and I appreciate Your Honor's concern along those lines. And the very simple and direct answer is that once constructed and irrevocably maintained in perpetuity, reserved in favor of Lennar Homes, this system capacity has to be maintained. Every user in the county pays the service availability charge, which was then called the base facility charge, which represents the cost to maintain the infrastructure. That's separate and apart from once you connect, then you've got the volume charges. Once you turn on the spigot and flush the toilet and turn on the shower. That's not the charge that Lennar Homes and then FVP were incurring. They are incurring the cost to now maintain the infrastructure that was expanded at their request.
Are other property owners in that area using this expanded facility now?
Yes.
And they're getting the benefit of it, even though
Well, I'm sorry, go ahead.
they're getting the benefit of the expansion, and Lennar and its successor now are not getting anything from it.
The system's expansion, that slice, that wedge of the pie, is reserved in favor of Lennar Homes initially and now FVP, the appellant, in perpetuity. It cannot be used by anyone else. If someone else comes along and wants to build another project, that capacity that's been reserved in perpetuity for Lennar Homes and its predecessor doesn't count. That can't be used because that's been permanently and irrevocably.
Even if it's never ever used.
Well, yeah, there's no actual use, but the use that Lennar Homes and now its successor, has is the ability to build these projects out tomorrow. This system capacity is reserved in their benefit. They have, if they don't want to build the property out tomorrow, they can market the property as having these entitlements which run with the land. The buyer of the property doesn't have to go through this process. There's already system capacity reserved in favor of these projects, so new impact fees don't have to be charged.
So this monthly fee that was initially paid and now is accruing as a lien against the property is for the maintenance of the infrastructure that was built as a result of Lennar's initial payment.
Exactly so, exactly so. And it's for that reason that not only is there a benefit to the property by virtue of this reservation of capacity, there's a correlative burden on Indian River County and its taxpayers. We would not have expanded this system absent this request. Therefore, we would not be incurring these maintenance charges absent this request. Lennar Homes was in the driver's seat at every turn of the road. And, for these service availability charges, for these maintenance charges to be visited on the taxpayers of Indian River County at this point, is just subsidizing a bad business decision, apparently bad business decision by Lennar Homes back in the day. So that burden on the taxpayer correlates precisely to the benefit that these properties enjoy from the reservation of capacity. And so we simply disagree that there's no benefit from the service. There's a very clear benefit from the service that's provided, and that service is specifically the irrevocable reservation of capacity in perpetuity in favor of the owner of that property, whoever it is. And so that is something that was done, again, purely at the request of the property owner. That property owner has the ability to redesign its property, they can leave the courthouse today, drive up to the county administration building, and hand us a revised application for the full amount of the 462 units, and we would be obliged to process that.
If Lennar had not made that prepayment of the impact fees, would the city have built the infrastructure that they did, or would they have waited until Lennar applied for the building permits and not even commenced doing the work that they did prior to that time?
The latter. Those impact fees are not due and payable until the time of the filing of the application for the vertical building permit.
Yes.
When you construct each home. When each home is constructed, the impact fee is due and payable. What is done in the meantime is as the county's utilities director testified, is that we maintain a buffer of 20% capacity, so such that we're ahead of the game. In other words, there's no requirement that we run our utility system at absolute maximum capacity 100% of the time before we're authorized and allowed by law to expand it at the request of a customer. That system would be inherently fragile and wouldn't make sense. So the simple fact of the matter is that once that application is received for the vertical building permit, there is system capacity there. There's that 20% buffer, but we have to add to that. So we're going to take this portion of the buffer that Lennar Home is requesting and allocate that to Lennar Homes and start building again for the next guy. One of the important questions that this case presents is relative to the statute of limitations. And the question here is when does a statute of limitations run on a claim for the refund of a non-refundable fee? And the cases, the City of Gainesville case and this court's decision last year on Australian properties underscore that there's two interests to be served here when you're analyzing when the statute of limitations begins to run. There's the right of the property owner to have notice of the fee or charge and have the ability to dispute it. There's also the need for the utility for certainty in making its expenditures and in economic certainty. The proposals by the appellant in this case that the statute of limitations begins to run when the number of units was reduced, or the reduced number was approved, or the abandonment of the projects, we submit are utterly impractical and unworkable. For example, the idea that the statute of limitations began to run when Lennar Homes reduced the number of units rather than build multifamily or reduce the size of the lots or the size of the homes and driveways. The problem with that is that it's a hypothetical situation. There are no buildings out there. There are cows out there. So that number is a moving target. It's not etched in stone in any way, shape, matter, or form. They have the ability, the appellant does, or its successor does, to reapply with a revised application for the full number of units. And we stand ready to accommodate that. That's a decision that's purely within the purview of the appellant. The other problem with this, it's totally unilateral, and there's no time limit on that. There's no reason, in other words, why the decision to voluntarily reduce the number of units couldn't come 5, 10, 15 years down the road. That's fatal to the need for the utility to have certainty in the economics of its decisions.
So because of the policy considerations involved, we should treat these impact fees as we do special assessment.
Certainly more in the impact fees, yes, certainly more along those lines, because we submit the only reliable and consistent way to harmonize the interest of property owners on one hand, to have the right to know that they have a challenge, and the need of the utility for certainty, is to make the statute of limitations run from the time the fee is paid. When the non-refundable fee is paid, that's frankly when you should start thinking about whether you want to challenge the refundability of that fee, rather than manufacture reasons down the road why that fee is otherwise unjust, unfair, inequitable, or unreasonable. The lines are there. The county's lines are there. They're ready to be hooked up for whomever wants them. So it's simply not the case, as was the case in the Cardillo case that Mr. Cornwell cites. It's not the case that there's no actual or possible actual use of this system. It's eminently possible it could happen tomorrow, because that system capacity reservation has been made and it continues. The reservation is perpetual, it is irrevocable, but that's exactly what Lennar wanted. Exactly what Lennar wanted. It's exactly why they prepaid impact fees years before they would have otherwise had to do it. And the simple fact of the matter is, had they only waited until vertical building permits were applied for, we wouldn't be here, because we all know now they were never applied for. These fees were voluntarily paid because they weren't required to be paid at the time they were. And that's the critical distinction. When we're assessing the voluntariness of a fee, the touchstone is whether the payment is to obtain a benefit versus whether it's to avoid a penalty. In this case, there was no penalty in Lennar's waiting. They prepaid the impact fees in order to obtain an irrevocable impact fee, irrevocable system capacity reservation in its favor, and that's what they got. Now, their successor wants to revoke an irrevocable reservation. With the court's permission, I would conclude with a simple observation that the scheme that the appellant is asking this court to put its blessing on is one in which, had the projects gone forward, every nickel of the profits would have inured, and rightfully so, to Lennar Homes, the Fortune 500 company and its shareholders. But now, after the worst real estate collapse in U.S. history, the costs that Lennar Homes incurred, that needs to be shifted to the taxpayers and socialized. They want a taxpayer bailout. And we submit that Indian River County taxpayers could be forgiven for believing we've had enough of that already. And the appellant has advanced no legally sufficient basis or reason why those taxpayers would be wrong. We'd ask the court to affirm both summary judgments under review. Thank you.
Thank you very much, Mr. Walker.
Very quickly, Florida law under section 163.31801 provides, in any action challenging an impact fee, the government has the burden of proving by a preponderance of the evidence that the amount of the fee meets the requirements of state legal precedent. The Supreme Court in our state has repeatedly said that in order to justify collection and expenditure of impact fees, the government must show the existence of a dual rational nexus. And I hear Your Honor's concerns about the business decision. It's always a business decision to pay impact fees. That doesn't defeat the requirement of this government to prove some rational nexus between the fee collected and some benefit conferred on the property in this case.
Well, they're saying that the benefit conferred on the property is that at your decision, they're ready to start off, connecting you up.
That doesn't qualify or cut it under the case law, frankly. What they tell you is that they've went out and built a buffer in their water and sewer system, a new water system for existing users is what they did. They issued a 5-year concurrency certificate when we paid the impact fees, saying the capacity for these projects already existed in their facilities. So that's a misleading argument. They didn't spend these impact fees to provide any benefit to this property. And that's their burden, and they failed to meet it. They failed to even attempt to meet it in this case. The concurrency certificates are part of the record in this case, and they're found at R96-222. They're exhibits I and J. They were 5-year concurrency certificates in which the county affirmatively represented that traffic, water, and sewer capacity existed for these projects on the date the impact fees were paid. Furthermore, with respect to what they characterize as user fees, that is monthly charges that continue in perpetuity, began in March of '05 for 462 homes. There's absolutely no possibility of ever being constructed. The court found they were just and equitable fees. Florida statute section 153.11C, water and sewer charges and sewer service charges, says, such rates, fees, and charges shall be just and equitable and may be based on or computed upon the quantity of water consumed and or upon the number and size of sewer connections or upon the number and kind of plumbing fixtures in use in the premises connected with the sewer system or upon the number or average number of persons residing or working in or otherwise connected with such premises, or upon any other factor affecting the use of the facilities furnished, or upon combination of the foregoing factors. Here, the property is not connected, has no possibility of being connected. This is not a valid user fee. It's simply a way of the county imposing the cost to maintain its water and sewer system, which is legitimately the cost of existing users, on anticipated future users. This court has struck such ordinances in the city of Cooper City versus PCH. It struck exactly, it made that kind of determination and finding that you cannot subsidize existing users' facilities by charging a disproportionate share of costs to new users. And in this case, they're not users. They're anticipated future users. There's a real danger in affirming this kind of an ordinance. You would lead to setting a precedent, because no one has ever done so in this state or any other state that we can find, allowed a charge for unconnected, unimproved properties based on anticipated future use. There's simply no service here to justify the charge, going all the way back to the beginning.
Excuse me, your position is, though, as I read your request for relief, is that this was appropriately decided on a summary judgment basis. It's not that there are genuine issues that need to be decided.
There are virtually no issues of disputed fact, and the facts are set forth in the underlying summary judgment proceedings and in the briefs and papers submitted to this honorable court. The bottom line is you'll have to ignore Cardillo, frankly, to decide the impact fee claim in favor of the county and sustain these summary judgments. It was a business decision, just like in this case, to pay the impact fee, and the court found that didn't matter because, again, the underpinning and basis for a government to charge or exact fees as a condition to a private property owner's use of their property is destroyed when there's no dual rational nexus.
Okay, thank you, Mr. Condo.
Thank you, and thank you.